The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. My name is Puja Patel, and today's episode is called Are the Critics Wrong? Understandings and Misunderstandings about the Robinson-Patman Act. Now, the Robinson-Patman Act, RPA for short, has a long and controversial history in U.S. antitrust law and economics. For decades, I think the view of many practitioners, academics, economists has been that the RPA actually hinders competition and results in higher prices. And although we've seen RPA claims appear in private litigation, there has been virtually no government enforcement in the past 20 years. But more recently, some Federal Trade Commission leaders and others have been suggesting that this should change. The inspiration for this episode was an article by today's guest that appeared in the spring 2024 issue of Antitrust Magazine. The article is called The Critics Are Wrong, How the Robinson-Patman Act Has Been Misunderstood by Its Detractors. And my co-host today is Aaron Yeater. Hello, Aaron.
Hey, Puja.
Can you tell us today about our guest?
Of course. Our guest today is Mark Poe. Mark co-founded Gaw Poe LLP in 2014. Since then, he's been first chair of 9 different trials or arbitrations, including cases in which he pursued claims under the Robinson-Patman Act. He has obtained verdicts, judgments, or arbitration awards in those matters valued at approximately $70 million. And he's also been the appellate counsel of record on multiple appeals. Mark has written articles and made a number of presentations about the Robinson-Patman Act, including the one you referred to, and including to the Federal Trade Commission. So we'll say hello, Mark, or should we say aloha?
We can say aloha, that'll be fine. Just a little context, I was telling the host earlier, I had taken advantage of the later stages of the pandemic to move out to Hawaii 2.5 years ago. I'd clerked out here and really fell in love with it. And so I was always waiting, looking for an opportunity to come back. So,
great, welcome.
Mark, for listeners who are not familiar with the RPA, could you briefly describe what are its key requirements and what was the problem that the statute was trying to solve when it was first enacted back in 1936?
So, my understanding is that coming out of the Great Depression, there was a sense that the independent merchants were being inhibited by the chain stores. At the same time that the chain stores were coming onto the scene, they were able to use their buying power to extract from suppliers, manufacturers or their suppliers, lower prices than their independent competitors could get from that supplier. And so Congress decided, there's of course many hearings and investigations, decided the solution was to ensure that competitors are being treated on the level playing field. At least they're treated even-handedly when it comes to the price that they are paying to suppliers for the goods that they purchase for resale. So there are kind of 2 theories under the Robinson-Patman Act. One is called primary line discrimination. I won't spend any time on that. It was a theory that had to do with the possibility of a large supplier essentially engaging in predatory pricing to sabotage a small competitor of it. Now that has kind of fallen by the wayside after a Supreme Court case called Brook Group. But there remains the other theory of liability for price discrimination, which is typically called secondary line discrimination. That means a supplier selling to two of its customers at different prices. And we talk about the favored purchaser and the disfavored purchaser. And so secondary line discrimination consists of the supplier charging a higher price to the disfavored purchaser. And of course, in almost all circumstances, the disfavored purchaser is a smaller business, an independent business. And the favored purchaser then is, typically a chain, but at any rate, a customer with significant buying power. So let me just go over the elements really quickly. What a plaintiff, the disfavored purchaser, needs to show to make out a claim for price discrimination is that A, it was charged a higher price than the favored purchaser, that it was in actual competition with that favored purchaser for resales of the good, that the purchases that the favored and disfavored purchaser made were of goods of like grade and quality, and that they were reasonably contemporaneous to each other. So just they're buying on essentially the same terms. And then 4, the plaintiff needs to make out a showing that that the discrimination may harm competition. And that turns out to be important in these cases in 2 ways, and I'll finish here. But first of all, liability is established by a price discrimination that may harm competition. No actual harm to competition has to be made out at all for liability purposes. Now, to recover damages under Section 4 of the Clayton Act, of course, you have to show damages, but one could, in theory, establish liability and obtain injunctive relief just with the possibility of harm to competition. Second, and I'll end here, in most antitrust claims, one has to prove, of course, not competition to the competitor, but competition more generally. The RPA is different, distinctly different. And this is from, certainly in the legislative history, but also Supreme Court precedent. Harm to competition is shown by proving harm to the competitor. And so essentially the plaintiff is just coming in saying, I was harmed, I lost sales because I was charged a higher price than Costco or Walmart, my competitor.
Thank you, Mark. That was a helpful overview. But let's get into the debate. Let me first start by mentioning a quote from Judge Robert Bork, who once described the RPA as antitrust's least glorious hour. What are these critiques that Judge Bork is alluding to?
My sense is for Judge Bork himself, I think he probably believed that price discrimination and the ability to price discriminate was actually desirable in the first place to foster competition between businesses. And to be honest, I haven't gone and studied his writings on this, but my sense is the thought is that if a chain has the ability to use its buying power to get a lower price from a supplier, why would we want to stop it from doing that? It should be able to flex its muscle, get a lower price. Presumably, it would then be passing that lower price on to its customers, either directly to end consumers or eventually to end consumers. And I suppose he might say, for the disfavored purchasers that are paying a higher price, either figure out how to be more efficient, figure out how to collect sufficient buying power so that you can, have that same negotiation, or differentiate yourself in some other way. Or, I presume, in some economists and, certainly laissez-faire antitrust lawyers would probably say, well, if you can't compete and you can't get that price, then you should go out of business, and that's desirable for the economy. So I guess big picture, I would say, and the main problem that I have with the criticisms that you see in the writings is that they're lacking in empirical support. They're just made as assertions that the Robinson-Patman Act does this and that. But to my knowledge, there hasn't been any empirical analysis or case study showing how, for example, the Robinson-Patman Act may have led to higher prices, that kind of thing.
Mark, in your article, you attack these criticisms in a few ways. And I think your first response, as you just said, is that the RPA doesn't result in higher prices. Why is that?
Well, I should admit, as I was just hinting at, I can't say empirically that it does not result in higher prices. My point is just, it seems that no one has yet established that it actually does. I would further add, after, doing a number of these cases and seeing how the price discrimination plays out in practice, I've come of the view that I think that criticism that it leads to higher consumer prices is just based on a misunderstanding of the act. It's typically described as the RPA prohibits discounts, but discounts to the favored purchaser. But in point of fact, Section 2A says nothing about discounts at all. It prohibits only discrimination between competitors. And so if one looks at it from the opposite view, what the RPA does is it prohibits a supplier from charging an illegally high price to the independent, to the disfavored purchasers. And what it really comes down to, I suppose, is it's just a question of what is the baseline, right? I think the critics are all assuming that the baseline price is the list price that the manufacturer set. And so anything below that is a discount. But if we look at it the other way, perhaps the baseline price, and I think as a matter of economics, it would make more sense to say the baseline price is the price that was negotiated between a strong buyer, let's say Costco or Walmart, and the seller. And so if you look at that as the base, and I mean, economically, I think one would say that a desirable price is a negotiated price. And I think the theory of economics, I assume it's still valid, is that an efficient market is one where the marginal cost is, or where the price is driven down very close to the marginal cost of production. And so unless suppliers are in fact losing money on their sales to Costco and Walmart, which in our cases, that is never happening, they are making some kind of normal profit. And so to me, it appears that the more sensible way of viewing it is that that is the baseline price. And what's happening is that independents are being charged an illegally high discriminatory price. And then one could also further imagine that the high price paid by the independents is actually being used to subsidize the lower price that is being paid by Costco and Walmart. And I'm not sure there would be many people that would even take the policy view, let alone an economic view, that that's a desirable thing that we ought to be doing, is using super competitive profits derived from small businesses to subsidize the business of big businesses.
Can you give maybe a real world example that sort of illustrates this point? You mentioned Costco, Walmart. Any example come to mind for you?
Well, yeah. So that's another point that I wanted to make, which is that, as we can see this from essentially every claim that is made, certainly from the private RPA plaintiffs. Every case I've ever seen, and certainly all the cases we bring, the plaintiff is not asking for the chain store's price to be taken away. It's actually asking for itself to be given the same low price that the favored purchaser is receiving. And so that would mean, in a successful RPA case, more merchants are being given the lower price, and they're presumably then passing to compete with each other, to compete with Costco and Walmart. They would be passing it on to their own customers. And so if that's true, and at least our experience in the cases shows that it is, enforcement of the Robinson-Patman Act means that more end consumers would receive that favorable price than the lack of enforcement. I would say in the settlements that we've had in our cases, at least the ones that have included a price component, it has always been the case that the supplier says, okay, we'll give your guy the favored price also. So I just, I think this is a great example of where the theory deviates from what is happening in the real world.
Mark, you referenced the economic view earlier, and certainly economists have various explanations for price discrimination. And it's a fact that it might enhance competition to offer different prices based on volume or exclusivity, or just, it may just occur in the course of competing for incremental business. Is your sense that the economists' view of the RPA is wrong, or just not empirically supported, or do we land somewhere in between?
So I'll quarrel a little bit with when you say the economist view of the RPA. The papers that I have read that are actually by economists seem to me to take the view that price discrimination, well, it's good for some people and bad for others. Enforcing the Robinson-Patman Act would be good for some and bad for others. I haven't seen an economist come out with a strong criticism. Well, you see some, but they're based on that simple misunderstanding I was just talking about. The RPA prohibits discounts. If it prohibits discounts, then yes, it's uncompetitive. On enhancing competition, I come back to what do we mean by enhanced competition? It's certainly whose competitive position is being enhanced. Certainly Costco's competitive position is enhanced when it's able to buy goods at a 20% discount compared to what its competitor is paying. And, you would suppose that Costco's customers are benefiting from that because presumably Costco is passing along some of that price savings to them. But then I go back to the same point I was just making. If the RPA is enforced where Costco's competitors are also getting that same non-discriminatory price, then their customers would be receiving that lower price as well. Now, and of course, that's all too simplistic. If there were just one fixed price, one would have to imagine that it's somewhat higher than the price that Costco and Walmart are currently paying, but significantly lower than the higher prices that their competitors are paying. But, that comes down to, as an empirical matter, do we know whether on average consumers will be paying higher or lower? I think we don't know. And then by my lights, we would then just fall back on the economic prerogatives that Congress chose. And it chose to enact a statute that it believed would preserve small businesses and preserve many competitors in a given market.
I want to talk a little bit about the enforcement activity of the Robinson-Patman Act. Mark, on the government side, RPA has largely been a dormant statute for the last few decades. But in recent years, there has been some talk about the possibility that the government may revive its enforcement of RPA. Can you tell us a little bit about what's happening with RPA enforcement under the Biden administration?
So of course, I don't have really good insight into their doings. I know, for example, Commissioner Alvaro Bedoya and FTC Chair Lena Khan, they've made some public statements in favor of RPA enforcement. The other commissioners, my firm hasn't had any contact with. But, from the public evidence, we know, they've at least opened an investigation against or into the pricing practices of Coke and Pepsi, which, many of our clients have complained about. You can see Coke and Pepsi being offered for sale at Costco and Walmart at a price that's lower than our guys have to pay the bottler to acquire it. And so certainly by definition, that means Costco and Walmart are receiving a discriminatory price. There's another one that has been in the public profile a bit, is an investigation and perhaps soon a lawsuit against Southern Glazer's Wine and Liquor, which is the country's biggest distributor of alcohol. That one is a bit interesting. Our firm filed a class action in California against Southern Glazers in June 2022. on behalf of all independent liquor stores in California, alleging that they are paying illegally high prices compared to the grocery chains they compete with. And here too, if anyone buys liquor, you go in and you'll see at, I keep picking on Costco, but you see at Costco, a bottle of your favorite liquor for sale, 30% less than it's being sold in an independent liquor store. That is not because Costco has a lower markup than your independent. It's because your independent has a much higher acquisition cost than Costco or the grocery chain is paying. But getting to the point, though, it's we filed that in June 2022, and then the first rumblings I heard about the FTC opening investigation was in the spring of 2023, and so I haven't asked the impolite question as to whether they were copying our lawsuit or not. But it'll be interesting to see how those two play out here in the next few months.
Mark, what about other developments on the private enforcement side? Notable cases we should be aware of, or other developments that folks should watch out for in the coming years?
I'm not sure. I think a big, the FTC's undertakings will probably be the most significant. On the private side, I'm not sure that I'm not aware of any firms other than ours that are even practicing in this space. So I'm really only aware of our own cases. We had last year a Ninth Circuit opinion called U.S. Wholesale v. Living Essentials, where we had represented, Living Essentials is a maker of 5 Hour Energy. We had represented several wholesalers alleging that they paid illegally high prices compared to Costco. And to my never-ending chagrin, we lost the jury's verdict on that. And then the court denied us injunctive relief, but we got to the Ninth Circuit, and the Ninth Circuit remanded the injunctive relief portion on the particular issue of how competing purchasers go about establishing that they are in competition. For all of the history of our cases, the district courts had been following the Supreme Court's case in Volvo Trucks, which suggests that to establish that your disfavored purchaser is in competition with a favored purchaser, you need to identify specific customers who have shopped at both. And that's the only way that you can establish competition. We were able to get the Ninth Circuit to kind of reaffirm its existing prior precedent that certainly in the kind of chain store context, competition is established just by showing that you are competing at the same level, selling the same goods in the same geographical area. And at that point, there's an inference of competition that I suppose could be disproved, but I think it would be hard to disprove. So I suppose that's that. We're continuing to bring these cases. Last December, we won a jury trial against the maker of Clear Eyes in the Central District. They have now appealed that. And so, I think that will probably also result in a published opinion. And I think we're in a very, very good position to have that jury verdict and injunction affirmed.
And you tried Prestige Brands successfully. Predictions for RPA enforcement after that case, and maybe in light of the election that's now just a few days away?
Right. Yeah. So that was the Clear Eyes case that I just mentioned, Prestige Brands. I have to say, so that was, to our knowledge, it's the first RPA plaintiff side jury verdict since the one in Volvo that was then vacated by the Supreme Court. So it's been many years. And I have to say that I don't really see a dam breaking where there's going to be a whole bunch of plaintiffs' firms jumping into this space. A Supreme Court case called J. Truett Payne made damages really restricted the damages that can be claimed. And class actions are kind of hard due to the individual issues that are often presented. So I just don't think it's the type of claim that you're going to have people like Huggins Berman and Hausfeld jumping into and filing. And then for the very small plaintiffs firms, like the learning curve is just so steep. The RPA certainly, it validates who was that guy? Malcolm Gladwell, who was it some aphorism, you have to do something for 10,000 hours to be an expert at it. It was maybe a year or two ago when my partner and I crossed the 10,000 hour threshold. But certainly, and until you have that amount of time, it's very hard to understand.
Mark, we always close our program by asking our guests to tell us something interesting or unusual about yourself that is outside your professional life. You've told us a ton about the Robinson-Patman Act today, and obviously of your move to Hawaii. But what else can you tell our guests that is unrelated to your practice of antitrust law?
Well, it's kind of spoiled. I think I spoiled it in the preview by saying that, part of the reason that I moved to Hawaii was to surf. I had learned to surf when I was out here clerking for Judge Clifton in 2003, 2004. And so now, I finally, had to go back to the mainland, but I spent 18 years dreaming of being able to come back here and surf every day. And so I go out every morning just before sunrise, about 5:30, for an hour of surf. I don't mean to say that it's not aggrandizing at all. It's we go to Waikiki on longboards, and so it's me and 8 to 10 other old guys out there catching waist-high waves. In fact, I might be the youngest among the group. But it's a great way. It is a great way to start your day. You come in at 7:30, run the kids to school, and then you're ready to dive into the Robinson-Patman Act.
Mark, we're going to move to this next segment, which we call the Curious Hats.
And now it's time for the Curious Hat.
I'm going to ask you a question that you are not expecting about your personal life. So here it is. If you were given $50,000 on the condition that you had to spend it all in 1 hour, what would you buy?
That is a good question. I'm so tempted to say that I would buy 50 surfboards, but that would be far more than a person would need. And so on impulse, I would say I would buy the latest model of Ford Flex that I can find. I had that car and it was perfect because a surfboard that's 10 feet long will go inside the car and you don't have to worry about surf racks. But then 2 years ago, 1 year ago, blew the head gasket, and so that car had to be taken to the junkyard. So I guess with 50,000, I'd still have much left over. All right, 30 surfboards and 1 used Ford Flex.
And a perfect afternoon to go with it.
There you go.
Well, thank you, Mark, for telling us about yourself, your surfing, and the Robinson-Patman Act. Thank you, Puja, for co-hosting the episode with me. And thank you to our audience for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.